you so much, Satyaraju Kalu sir, for chairman of this branch. And again, I would greeting to my Apurva ma'am and Mubala sirs and Brijpal sir for giving me opportunity to share my opinion and views on the intellectual property rights. Should I share my screen, sir?
Yes, ma'am. It's all yours, ma'am.
Yeah. Thank you. My screen is visible to you?
Yeah. Yes, ma'am.
A warm welcome you all for session on intellectual property rights. This webinar should provide general awareness on introduction of IPR and the various other provision. Now, IPR, there are various intellectual property rights such as trademark, copyright, patents, industrial design, geographical indications, and various other IPR, in which we will get the protection of our brand. In today's webinar, we'll discuss about in-depth of trademark, patent, copyright, industrial design, geographical indication, and trade secret. Now, look at these three boys. Here, they have confused about that work protection. They are also confusing that how they protect their brand via patent or copyright or trademark. And again, this IPR, this is a new avenue for all the chartered accountant. They can also do practice in that, like the registrations of trademark, also appearance before the trademark registry. Also, you can easily file the copyright application, patent application, or industrial design, geographical indication, and trade secrets. So this is again the new avenues for all the chartered accountant members. But again, if you are confusing sometimes that whether I have to protect my brand under the trademark, whether I have to protect my brand under the copyright or various other IPR. So in this webinar, I will resolve all your doubts or the questions relating to trademarks, copyright, patents, or the industrial design, geographical indications, and the last one, that is trade secret. Because the basic understanding which must be required before you filing the application, that how you have to check the class number, how you have to trace whether the brand whether already registered or not. So there are the so many things that you need to check before filing any application with the trademark registry. Basic question arise in your mind, that is, as sir stated in the starting, that the intellectual property, again in intellectual property, that is completely for creative mind, and that is a new category of property. So here there is a two different meaning of intellectual and the property. Now this is the form of an inventive solution or a means to harness an opportunity or overcome with the problem. So here I have mentioned one slogan, that is think, create, and inspire. So if in case of in your mind, in case of any creativity or idea or concept, so you can also protect all your ideas and creativity through the intellectual property rights. This intellectual property, which will be basically divided into two parts. Number first one, that is industrial property, and the second one, that is copyright. Now this industrial property, which is also divided into four parts: patents, designs, trademarks, and geographical indications. So all these are part of industrial property, and copyright is again the different portion. Now creativity. What is creativity? So in case of your clients are again preparing such softwares, or if they have something new logo or slogan or something they have prepared like their articles, research papers, or anything else, you can give advice so they can protect their brands. Because nowadays competitions are going on and people can easily misutilize your brand, or there are higher chances that somebody is already misutilizing your brand with the same name, with the same color. But if your brand is not registered, if your client brand is not registered, then how you have to protect your brand. So first one, that is, if brand is completely new, completely creative, then you should be first registered under these 6 types of IPR. Now there is invention and innovation. So invention, here there is a 2 different terminology of invention as well as innovation. Invention, that means
I've been the
computer one box.
invention and innovation. So invention and innovation both are completely different, because these words are easily interchangeable. But invention, that is completely new. And again, for in patent case, in the patent case, all the brands or the machines, that principles must be new, because it must be the inventive product. While innovation, that means something existing product is there, so you just have to something new utilization in the existing product, so that would be treated as an innovation. But in the case of invention, an invention that is completely new. In patent registration, the patent registry, they first have to check whether your product is covered under the novelty. Novelty, that means your product is completely new. If your product is completely new, then you are easily registered under the Patent Act. Now, what should happen if you are not protect your inventions? So what happens if you do not protect your invention? Number first, somebody else might patent them, somebody else might take the trademark on them. So as I said earlier, one of my clients, I just also give some of the practical cases which already I have handled in the past. So one of my client name is again the Digiwagon in the same company, which is also the registered Digiwagon in also Hyderabad, the same name. And they have also the misutilization in the name. Now, my company name is also Digiwagon and that company name is Digiwagon, but that company has not registered trademark and my client has a registered trademark. So we can easily file the infringement suit. And again, that is also affect to my goodwill of client. So I easily file the case of infringement. So if you are not protect your invention, if you are not filing the application with the trademark registry, then this protections you will never get. Next one, competitors, they will take the advantage of your inventions. So easily somebody else take advantage of your inventions. There are higher chances that any person can take the license, sell or transfer technology will be severely hindered. And the time, efforts, utilization of the resources and the labor, that will be completely lost. So these are the higher chances that the time, efforts and labors and utilization of the resources all will be the completely lost. And the funders, that will be discouraged. So here again there is a question arise, if you are preparing your brand and if you have something unique name of your product or of your startup, and if you are not protecting, and it will take a lot of time to creating your brand, to creating something new name or logo or something else. But if you are not protecting and somebody else also take the same name with the same brand, and maybe your mark is not registered and their mark is registered, so there are higher chances that is that person can easily win because your mark is not registered. So this all are the chances if you are not protect your invention. So first step, if your brand is new, if your logo or something that is completely new, then you should always protect your logo, brand name, or either any of other IPR. So you should always give advice to your client, whether they are incorporating such a companies or the company name that is good. So again, the first step that we should also file the application of trademark application. Nowadays, incorporation of company and LLP, if the same name is also registered with the trademark, they are not allowing, number first, they are not allowing to use the name because the same name is already registered under the trademark registry. So you are not allowed to use this name. So again, this is important. So first, if your name is again unique at the time of the incorporation, then the next step after the incorporating, that you should file the application of trademark. Now, how would you feel if someone copied your poem without your permission and got praised by the teacher? So this is just a small example that I have posted over here, so you can easily identify that someone else showing that this work is original from your side and this work is actual by done by you. So what you felt at the end? So now imagine how an intellectual property owners will feel when someone copies their novel, invention, or trademarks without their permission and makes money from it. Because again, this is our important intangible assets, and intangible assets have their own values. So as sir discussed earlier, that the valuation must be done by the chartered accountant. So this is again the new area that you can value for the like IP valuation, like the trademark valuation, patent, copyright. So many valuation report that you can submit at the time of the merger, amalgamation, transfer of company, and so many times that we need to submit for this purpose. Now, the same question, that is why intellectual property which is required. So first, that is to protect your own unique creativity and invention. So you just have to protect your creativity and invention. Secondly, to get an economic return on funding invested in research and development. So just you have to get an economic return. So you get written something on it, on the funding invested in the research and development, to get your reward and the recognition as it is a fruit of your hard labor, efforts, and time. Because you will also earn so much money from it, because IPR is again the intangible assets in the valuation. You will also earn the money, and to own your invention and creative works, to create an intellectual assets for licensing or the selling, and to prevent someone from misusing if your brand, and if they are using your brand, then you can easily file the application for the infringement suit. So this all are the basic reason behind this, that why the protection must be required, why you have to file the application with the registry, and you just get the protection of your valuable brand. What is IPR? So intellectual property rights are basically legally awarded ownership rights to the inventor. Here they have to provide the exclusive right. That means exclusive right are actual with the owners of that particular company, or that particular the proprietor or anyone else who has filed this particular application. They give the creator the right to prevent the others from making unauthorized to use of their property for a limited period. So again, this will be take or unauthorized to use of their property for the limited period of time. Now, in case of trademark, so you can take the protection for the 10 years. You can also make the application of the renewal for the next 10 years. So every 10 years, you should be remembered that the renewal application must be filed. Secondly, that the question arises in case of the copyright. So in the copyright, you will take the protection till the death of that particular author, or there are certain other criterias. And again, in the patent, you will get the protection of particular 20 years. So geographical indications and industrial design, you will get the protection of 10 years. So different IPR have the limited period for using all this. Next one, that is a startup and IPR. Startups have been recognized as a powerhouse of innovation, technology, and the ideas. The government of India, they have started the scheme for facilitating startups intellectual property protection for their innovation and creativity, and promotes awareness and encourages IPR protection among the startup. There are so many incubation centers in India. And again, government of India coming with the scheme, that is startups intellectual property protection. With this scheme, any startups can, if you have this startup certificates, And if you apply for the trademark, you will get the benefit for the 50% of that particular charges. And patent application, you will get the rebate of 80%. So this type of the protection which will be given by the government of India. And intellectual property rights are also an important reason behind the success of Indian startup ecosystem. So nowadays there are so many incubation center which is going on across the India, basically in Gujarat, Ahmedabad, and various other places. By way of this incubation center, if any person who have something new idea, or so they can easily take the protections, they can easily file the application with this incubation center, they can easily get the funds and various other benefits. But the government of India, they are coming that they are providing the free services for the facilitators. So there is no such fees for the facilitators they are charging. And again, the rebate in filing the application fee, that is 50% in case of trademark and 80% in case of this patent application. So you can see that the government of India also planning that more and more business are coming day by day, and so many people can take the benefits. And also this IPR, intellectual property rights protections, they will get for the startups, because in the startups you need to take protection of all your names, your logo, whatever the websites if you are preparing, then you just have to protect everything. Startup India benefit, as I already discussed with you, that is fast tracking of startup, that the patent application. So again, that easily fast track, that means easily actually the patent application, it will take much time, like you can say that the 1.5 year or more than that sometimes, but your application will be not accepted by the patent registry. So in that case, that here if you file with the Startup India, then you just have to take the replies within a 1 year or maybe the shorter than that. So this is again the fast tracking of startup patent application. Next one, that is panel of facilitator to assist in filing of IP applications. So here facilitators, they will give the advice with the free. They will not charge anything for filing of IP applications, because all the cost which will be borne by the government of India, so you will get the benefits from that. Next is government to bear this facilitators cost. So entire cost of facilitators, what they are guiding for you, and if they are filing the applications on behalf of you, so they are not charging anything from you, because government of India, they will directly provide this cost to that particular person. And the last one that will get the benefits under the Startup India scheme, that is rebate on filing of application. So rebate, that means you can say that, as I said, in the trademark application, you will get the benefit of 50%, and in patent, you will get the benefit of 80% rebate. So this will be the benefit for the so many startups, those who want to start that particular new venture and new business, they can easily start. Now, in this particular slide, you will able to learn that there are various types of intellectual property, as trademark, patent, copyright, industrial design, geographical indication, and trade secret. With this slide, you will be able to learn that there are different type of IP, intellectual property, and they have the different segment. For an example, trademarks. So you are aware about that you can take the trademark on name, but you are not aware about that the trademark can be taken for any brands, for that particular logo, for slogan, for wordmark, for taglines, and various such other things. So here in this case, you will be able to learn that there are so many other marks that you can also register. Here just I have to put one symbol of McDonald, that is M, that is the symbol of M which shows the McDonald, and I am loving it, that is the slogan. So again, there are the various slogan which is also registered in India. Next one, that is the patent. So patent, that is technical inventions. So in case of any persons who are coming with the new machineries or who are coming with some new ideas, so they can easily register that patent, because in India day by day there are so many patents registered. In fact, GUSEC basically in Ahmedabad in the last year they have registered more than 200 patents filing applications. So this is again good that we can easily find out that there are so many patents again in day by day that is going on. Next one, that is the copyright. Now copyright is again a new concept for you, that if you are writing any research paper, if you are writing any books, if you are writing any articles, then you can easily protect of your work. But yes, you need to check that whatever the works that you are writing in your article or research paper, that is completely new. It is not copy paste from someone's research paper or someone books or the copyrights. Then you will not be able to take the protection in that. In copyright application, you can easily make the application on behalf of your client. And again, this is a new area that chartered accountant also play a role, that filing the application of copyright. Next is industrial design for aesthetic industrial product. So there are so many different type of designs. If you can see, this is only one design I have put it over here. That is a Coca-Cola. Apart from that, there are so many designs like the Mazda bottle, if you can see, or the various other shapes like the sometimes the chair shapes, or various other machinery shapes, or the car shapes, or various other things are there. They are again completely different. So in that industrial design, you will be able to identify, you can also predict but particular the shape of this particular product. Next one, geographical indication for specified place with that famous product. Now the famous product, like in case of, I am not actually know about what is the famous product in the Andhra Pradesh, but like if in case of any such famous product is there, then you can also protect the geographical indications, like basically in Gujarat, Junagadh is there, there is a Talala Keri is there, mango. So already they have made this application for geographical indications. So this is a famous for that particular city, that is Bikaner is particularly famous for that Ratlani Sev. So this is that we can easily get the protection for this. Yeah, someone also mentioned that in Andhra Pradesh there is Tirupati Laddu. Yes. So in case of Tirupati Laddu is there, so again they have made the application of geographical indications. So apart from that person, nobody else can sold this product. So this is like by way of this also they can get the protections. Sometimes happen that in our clients they are not able to know about that how they have to protect IP. Sometimes also happen that some other clients, means other people, can also use their names, but after sometimes after 2 years 3 years they are able to came to know that this person is also using same name with the same product. Like there is a one of the case with the dairy milk also, and there are so many cases which is already going on in that. And in that we have to identify easily that this product is again completely different, but they are using with the same dark blue color chocolate and various other things. One of the recently case of the eclairs, again in eclairs there is a small chocolates, someone is also misusing of this brand, then they have filed the infringement suit. So your clients are not having this idea or knowledge that, oh, this can also be protected, because in our day-to-day incorporations and various LLP services, some of the members are also providing services under the startups, like the startup certificate. You can also give advice to your client that you, after the incorporation, they have to make the application under Startup India. Under the Startup India, there are so many benefits, like number first, that is cooling period of the tax benefits they will get. Apart from this, they will be get the benefit of this trademark and the patent application, that is 50% rebate and 80% rebate in patent. So make people are willing to know that they will protect this brand, and they will also mention, once you file the application with the registry, you can put this TM symbol, and after once you will get the register certificate, then you will able to mention the R, because your mark that is easily registered. So this is that thing that protection must be required. Without protections, or this is our, in our profession, that we must be give advice everything with our client, that yes, you can go ahead with this, you can do this, you can protect these things, or you can file the startup application. You can in case of MSME certificate, if you have, then 50% rebate that you will get in the trademark applications. So this type of advice you can give with your client. So this is again important, that there are total 6 types of IP, that is intellectual property. Now each type of protections and what it protects. Number 4, that is trademark, that will protect while identifying that signs and symbols. Patents, which will protect for any inventions of new machinery and anything else. Copyrights, that will be the protect from creative expressions of creators. Industrial design, that will protect for ornamental designs of products. Geographical indications, that will protect for identifying place names with that product. So as I said, some of members are also replying with the same, that in Andhra Pradesh famous, that is Tirupati Laddu, and in this Rajmundri, that is rose milk. Okay, so this is a famous product, and we can easily take the protections in that. Now, maybe you are not aware about this, but the Coca-Cola, this is again one of the big brand in India. And the Coca-Cola, they have taken the different IPRs in only with the one product. And you can see in this slide that the Coca-Cola has taken the design protections. They have also filed the application with the patent, and also that is registered, trade secrets, trademarks, and copyright. Now again, one of the confusion that is arise, that how they have to file this totally 5 IPRs protected in one brand. Number first, you can see in this bottle, design. Design, this is for the particular shape of the particular product, you can take the protection. Secondly, that is a patent. So patent, that is new invention. They are coming with the new invention for how they have to make this Coca-Cola. So again, they have to file this application. Number 3 point, that is trade secret. Now they do not want that somebody wants to come to know that how they have to prepare this Coca-Cola, or what are the process behind this making this Coca-Cola. So they do not want to disclose this process. So that's why they have to take the trade secret. Next one, that is trademark. Trademark, you can see that the name of Coca-Cola that's written in something language, like something different, they have their language, and the red color. So again, they have to take the protection in that. And the copyright, that is process of making the Coca-Cola and the particular shape, they have to take the copyright. So again, basically what it happened, that in that case, that we should able to take the protections in the various, like the design, patent, trademark, and the copyright. So we'll be able to know that only in one product we can take the protections of 5 IPR. So this is again easily we can understand. Next example that I have mentioned over here, that is a different IPR in iPhone 7, or whatever the iPhones which is coming with the new updations, that again trademark, patent, design, copyright, and trade secrets. First one, that is the trademarks. So because again the name they have written, that is again the new, so they have to take the protection in that trademark. Patent, as I share with you in the design case, or in the case of the Coca-Cola, because of the how the what are the machines they are using and how the process are working in the iPhone 7, so they have to take the protection on it. Now 3rd one, protection, that is the design. You can see here the shape of iPhone 7, so they have to take the protection on this. Copyright, again, they have to take, and trade secrets, because this is a product like international market product. So here they have to take the protection in the entire world, and they do not want to disclose this kind of the process and everything with anyone. So they have to take the trade secret on that. Now let's start our first IP, that is the trademarks. So let's start with this trademark, one of the most important intellectual property rights and one of the most important assets. Now, guess this is a common trademarks. There are so many common trademarks which I have mentioned over here, and I know everyone knows about this marks like the Apple, McDonald's, and the various other Mercedes-Benz logo, also that Pepsi logo, and the Mickey Mouse, Spider-Man, and Nick, and Nike. So there are the various other marks which I have showing to you, Android, and again there are the Shell petrol pumps, and various other marks are there. Here you have to understand this mark, some of the marks are designing in such a manner, whenever we see this logo in our mind, which reflect, yes, this is for this brand. So why this brand is important? Why on the shape of the Coca-Cola we can easily identify, yes, this is a Coca-Cola bottle. So like the Nike symbol, you can say that, right, we can easily identify, yes, this is this. Like the windows, like Windows symbol is again here, you can easily identify that this is a Windows symbol. McDonald with the M, you can easily identify, yes, this is exactly McDonald. Apple symbol, we can easily identify, yes, this is iPhone, or which is Apple product, you can easily say. So this is the Apple product. So with this, I can say that why these brands are important, why these colors, why this slogan, why these logos are important. Because sometimes in the rural area, what was happened that in the rural area, people they are not that much literate, so sometimes they have to identify that product with the particular colors or with the particulars of this logo. They have to identify, yes, this product is it. Like the Colgate, they have the red, and again they have the specific symbol, so easily this people will be identified, yes, this is Colgate product. Now you can see over here in this Coca-Cola, the name they have taken, logo type, symbol, slogan, and the color. So you can see here that the Coca-Cola, they have taken the name, logo type, that is a Reebok, easily McDonald, that were particular symbols, and the shape you can easily identify that the shape, that is a slogan, I am loving it, shape joy Coca-Cola, and the color, that is orange color. So what is basically the trademark? So trademark is anything which allows the market to tell your products and services apart from identical or similar products and services of everyone else. Trademarks, which is again completely different from your product to another product. A trademark which will be easily described a feature of characteristics of your products as well as the services. Once you acquire this type of the trademark, that will be valid till the 10 years. But again, after 10 years, it's your responsibility that you should have to renew this trademark every 10 years. What are the functions of trademark? So the functions of trademark, that is easily identifying the sources of goods and services, which will show the uniform quality of goods and services, which will again create the goodwill and the brand recall. This type of trademark which will be easily differentiate with your brand in the market, so you will be able to distinguish your product with the other product. You can easily create goodwill in the market. You will be the advertise your product, and it will be ensure the genuineness of the product, and you can easily identify if your product is your registered and genuineness of the product must be there. Then you can easily differentiate, because as I said, there are so many competitors in the market, right? But if you have to distinguish your product, if you are differentiating with them, then you can easily protect with them. So this is identified the source of goods and services, and you can easily create your goodwill in the market. Now there is sometimes so many confusions with so many people, that when I have to use this TM, when I have to use this SM, when I have to use this kind of R. Now there is a simple concept behind this. Once you make application with the trademark registry, and trademark registry that will allot the application number, on the same day you can start using TM of your particular product. And you can see in here Intel Inside. So Intel Inside, they have mentioned the TM because still they have application file, but the registry that will not issue the registration of certificate. SM, that will shows a brand of services like the service mark, like the education institutions and various other insurance regulatory affairs and the banking services. They are covering under this particular the service sector. So they can use this SM once you make the application with the trademark registry. And the next one, that is R. R, that means registered trademark. Once your application is accepted and advertised, after that they will get the certificate of registrations. Then and then you can put R symbol on your brand. So that is trademark may be designated by the following symbol. Once you make the application, then put the symbol TM, and once the registry will issue the certificate of registrations, then and then you can put the R, that is registered. Now question arises, that is, if your clients are belonging to any sole proprietor firm, if your clients it is in partnership firms or the company, or you can say that governments or again the trust or anyone else is also there, so they can easily file these applications. And in case of the partnership firm, any of one of the partner can make their file application, and section 8 company also file this application for the trademark. Now you just have to check this particular list of trademark classes. There are total 45 classes, in which class 1 to class 34 it's for goods, and class 35 to class 45 it's for services. Before making application, you just have to go with this website, that is www.ipindia.nic.in, in which you have to go with the trademark, and you just have to take the trademark search. In that, you just have to mention the name and also mention the class. Now, if your company, which is in a textile, or you can say the fabrics, you have to mention the class 24. If your company, which is in the clothing and footwear, then you have to mention the class 25. If you are belonging to the medicines, then you just have to mention the class 5. Again, there are so many clients are there, and so many clients are here, and they have to again see that they have to file the multiple classes, means some of also class cover under 2, 22, 32, 33. So they have to make one application with this four classes. So again, that is multiple classes are also there. Now in that multiple classes, that is 99 application must be filed. So they have put it like 99 numbers. So multiple classes are also there. So you just have to under which class your particular goods or either the services. If the service sector is that, you need to check class 35 to 45. So after the checking, if the same or original name, which is again in the trademark registry, then you are not eligible to file this application, because there are the higher chances that the trademark registry that will issue the objections, and there are chances that if you file the reply on that, and you have to appearance before the registry, because you have to take this trademark anyhow, then you have to go with the registries and appearance and anything can be possible. So this is also possible with the same name if you can apply. So what types of the trademarks? So that can be the register. Number first, we can also register a word, as I said, that is word of the like company name, that is a credence. So credence word I have to protect. Letters, you can see McDonald M, that is only the letters. Numerical numbers can perfectly constitute of a trademark. And trademark, which may also consist of a device, brand, heading, label, ticket, name, signature, word, shape of goods, packaging, or combination of colors, and any other combination thereof. So now you're just able to see that there are the so many trademarks. Earlier I also said this with you, that name, yes, again you have to take the trademark. Your particular logo, like you can see over there, that is a logo of Nike or any other logos are there, renowned logo of Coca-Cola. You can also take the protections. Numerical number is there. Only the letters is there, only the name, then you can easily protect with that. And again, in Coca-Cola case, I have explained with you that the particular of shape of goods, you can take the protection in the trademark. So this is that thing. There are the various types of the trademark is there. Now again question arise that what cannot be registered as a trademark. Number first, that is non-distinct words or symbols which is not distinguish your brand with the other brand. Common words like the name of God, like Mahalakshmi, Saraswati, Parvati, this type of God name you can, which is in the common use, or the common name like the if I can say the mantra, or very such common names are there, you cannot use common name, because a common name which is already, or why they are not registered as a trademark, because this name which will be again simple, which is not unique. So that's why this application which will be not accepted by the registry. A square can be trademark for any product, but it cannot be trademark for a product which is square in shape. So if the square in shape and you can take the product on the square name, so that cannot be possible. And any trademarks that offends a community or religious sentiments cannot be a trademark. Now you cannot take a trademark on Om symbol. You cannot take trademark on the Trishul symbols. You cannot take trademarks like which offend any community or religious sentiments. So this kind of trademarks applications, they are not entertaining, and with the first instant they have to reject our application. So this is what cannot be registered as a trademark. This all are the basically the types of trademark. That is a word mark, collective mark, certification mark, service mark, sound mark, logo, and 3D mark, and the smell mark. This is again something new for you, that is, yes, this can also be possible. Word mark, I already told you that if your company name is somethingly unique, like for example, Levite, or something which is ER Development Foundation, right? This is something new name. Then you should have to protect once you make application for LLP registration. The next step that you should protect your trademark. Collective mark, that is Collective Association of India. That is Life Insurance Corporations of India. Certification mark, that is ISI mark is that. So this is for that. We can also use serve any education institution, Indian Post Services, we can use for the service mark. Apart from this, there are other marks like the sound mark. So Intel voice, I think so every members have heard about this Intel voice. So they have to take a particular sound mark on that logo mark, like you can see this is 3 mark. Now in this Kit Kat or this particular the Nestle product, they have the shape. So 3-dimensional product, that means something that is new for this. So they have to again take the trademark on that. And smell mark, again smell mark, perfume smell. So again, you are surprising all the members how it's possible. But the first, which is in the international like 2007, which is come up with this concept. And after that, so many smell marks are registering in India. Again, they have to, this is again completely depend upon registry. They have to check whether there is a something new brand or not. Then we have to register this particular of this smell mark. Now, there are so many refusal grounds of registrations because I am trademark agent. So I have so many applications till now filed. I have also appeared with the trademark registries, and day in, day out, we have to also reply whatever the objections which is coming. So my area of concern that how I need to protect my client brand. Now, refusal grounds, whenever you are filing this applications, then you just have to check that similar name which is not available or which is not registered. Second, if similar name in registration, then ma'am, what we should do? Then the second one question that you just need have a strong reply, because as I said, within 10 days you will receive the objection from trademark registry. That under section 11 similar mark is there, and under section 9, that is they have like the confusion or it is not easily identified. So this is basically the two class, section 11 and section 9. You will receive the objection from that. Section 11 is very understandable, that is similar, क्योंकि जितने भी brand similar होगा, they have to make in this particular letter that all the brand is registered. Now how you have to apply this brand. Now I have to file this reply within 1 month with a strong reply that yes, my brand is completely new, completely different, it's distinguished. We have established in this year, we have turnover of this amount. So easily we can take the protection in that. If register is not satisfied still, then I have to, then after the hearing appearance, and I have to appear on that. So this is a refusal grounds of the registrations. If your distinctive character, if descriptive, if not generous, it's a create confusion. If you are using under the prevention of the improper use, and the shape of goods is again not something different, it create the confusion in the market, they will easily reject your brand. Now, what are the advantage of trademark registrations? It will create the brand awareness. It will take a time, but after the stage, you will be able to identify, yes, this brand is again important. Because nowadays, people can easily identify that brand with the logo. People can easily identify it with the brand with a particular slogan or various other kind of that things. So this is a brand awareness. You can easily protect your goodwill in the market. So this is again possible that you will protect your goodwill, because as I said, that is intangible assets is that. So you should be protect your goodwill. You will build your brand image. You will legal ownership of business brand. You have to develop your IP business assets. You have to recognition of the product quality, and this will be protected for the 10 years at a very low cost, because this is the bifurcate for in case of you are a sole proprietorship or the partnership firm or the company or the LLP, whatever the case may be. And in the proprietorship, the fees of registration that is 4,500. And if you are a company, LLP or partnership firm, and if you have the MSME certificate, then the same fees that will be 9,000. But if you have the MSME certificate, then the same fees will be 4,500, because 50% you will get the benefit. So this is the protection of 10 years. You will get very low cost. You can also protect your brand in India as well as international market. International IPR is also website is there. So WIPO, that is World Intellectual Property Organizations. So you can also protect your brand over in Dubai, USA, or whenever your product are importing or exporting, you just have to make the register over there, and which will easily attract to the human resource, because if the logo that is completely different, then you can easily identify. As I said, this is the website of particular trademark registry, and they have just, you need to check whether the name is available or not. And then after the examine and application, and after the exam and application, there are chances either your application is accepted and advertised, and either your application that will be objected, then within 30 days you have to file the reply. And if they are not accept your object, then within a next 1 year, or it may be take the 6 month, the first hearing that will be appear, and in the appearance you have to make all the replies whatever that is coming, and you can keep renewing your trademark every 10 years and forever. Every 10 years you have to make rupees like 9,000 rupees for your renewal application. Now the second most important concept of IPR, that is the patent. So patent history in India, if you can see, that is 1856, and recently Amendment Act, that is 2050, and that is the Grand Indian Patent Act, that is Grand Patent, which is governed by the Patent Act in 1970 and the rules 1972, and which is operative for whole of India. Now, what exactly the patent? There is again the new area which we can say maximum time this patent application which will be filed by the patent agent, and we have to clear this examination. So the lawyer, they have to clear this examination and file, but we can also make the applications for make that patent agent if you clear those examination. Now the patent purpose and policy encourage research and promote the inventive genius, to secure for the inventors for awards for inventing. So how you have to protect your ideas, how you have to protect your machineries. Now let's take example. If you are coming with this new electric vehicle, now that is again completely new, then you can take the inventive innovation, take the patent on that, maintain the flow of inventions, to enjoy that all the rights with you, or sometimes or every time you will get back commercial return to the investors for the time and the money which is spent generating of new product. So this is that the patent which is again exclusive rights that is granted by the state for an invention to the inventor. The applicant is required to disclose the invention to the public by providing a detailed, accurate, and the complete written description of the invention in patent applications. So you just need to have the protect your invention. You just need to have to protect and file the proper disclosure. It gives owners exclusive right, and again this will be valid till the 20 years. After there is no right for the renewal, again you have to file fresh applications. In the patent case, we just need to check about whether the product that is novel, that it must be the new. It must be the new, original, and unusual. In useful, it should be the useful to the industry. It should be the non-obvious to a person which is skilled in the art. Now you can see over here, that is an old telephone. You can see X-ray machine, and this is the tablets. This old phones which is now not in available, because we all are using the mobile phones. So this is a new product. Second one, tablets. So tablet is something new before 5 to 6 years. This is a concept which are coming with the small laptops. So laptops which are again converted into this tablets. So they are new. They have that different features. So this is the invention. So again, we have to take the protection over here. Same in case of the X-ray machine. That is the last second one point. And that is something new machines they are coming with that. And in India, there are so many machineries are there. They have coming with the new ideas and something they have developed in that. So they have to take the patent on that. As I discussed with earlier, the concept which is coming in India, like the e-car, electronic car, or electrically which can easily charge. This concept is again new. This is innovative. So we can take the patent on that. Next one point that what cannot be patented, because as I discussed with you, that is in the trademark case, there are so many trademarks that we cannot protect. So what cannot be patented? Number first one point, that is frivolous inventions. Inventions which is contrary to the public order. And if you copied your invention from someone else, and if you are showing that this is a completely new invention, so this cannot be possible. Invention which is related to atomic energy causes serious prejudice to health or human, animal, plant life, or to the environment. So which is again serious prejudice to the health or human, animal, plant life, which cannot be the protected. Patent which is on the plant, animals, and naturally occurring the microorganism. Any process for the medicinal, surgical, and curative diagnostics therapy, or any other treatment of human beings or similar treatments of animals cannot be the protected. So this all are the things that we cannot protect through the patent. Whenever you are making these applications or thinking about that, in the patent, just we have to take patent search report. We have to check the patent search. Same as like the trademark. Trademark, I have say that in the trademark, you just have to go with this website www.ipindia.com, and in that we have to go with this trademark portal, and just you have to check the name. Same is like of the patent, you just have to this website. Second option, you just have to click about the patent, and after that you have to take the search. Again, there are so many classes over there, you just to check in which class you have to fall. And in patent application, you just need to check first inventor of invention. Second, you need to check that is assignee of inventor. Third, you just need to check that is legal representative of the deceased person. So first, inventor of invention, assignee of inventor, legal representative of a deceased person. So in that case, the patent must be required. So this is a basic process. There are basically the three types of patent. First is utility patent. That is from innovations, that is provide something new results. Second one, that is the design, that is particularly the shape of product. If you are coming with something new, that is aesthetic design, ornamentation, or something that is already exit, no change in the functionality object, and only gives a novel appearance. And the plants, if the plants which is reproduced, which is crafts and the cutting, that is again you can take the patent. Now, patent applications you can also file in India. You can also file in outside of India. But sometimes there's situations which will arise in so many people, that in case of if we have filed this application in the USA, they have accepted our application for patent, and the same application we filed in India, the same application which will be rejected by the Indian Patent Registry. So is it possible? Yes, it is possible. Refusal of the patent in one country, that doesn't mean to terminate in one country. So vice versa, that can be possible. Or again, if you can, after that, if you are planning to file this application in the UAE, they might be accept your patent application. So that doesn't mean that Indian patent registry, they will not accept your patent application. That doesn't mean that USA, UA, UK, they will also not accept your patent application. So this is something different. Different country, they have the different opinion for the same. So some countries might accept, some countries might not register for the same. Next one, that is the copyright. So again, there are so many members over here. They are also, maybe they are doing the PhD, or maybe the research scholar, or maybe they are writer. So this copyright may be useful for you, that this copyright which will get the protection for your research paper, for your articles, for your books, or various other things, you will take the copyright over here. Now, object of copyright law, that is to encourage authors, composers, and artists to create the original works by granting them exclusive right to make the copies and sell them number of years. For an example of book, you can take the copyright in book, you can sell the copies, you can take the royalty in it. So again, that would be benefit. Now, what is the role of chartered accountant over here? So again, apart from the audit practice and any other things, you can also be provide the services of copyright, IP registrations, various IP registration like the trademark and copyright. You can also make application with the copyright registry, because there is no agent here over required. Anyone can make the application with the copyright registry. Here that is like for taking the protection for your research paper, or something like that, an article. The fees for copyright application is 500. You can charge any professional fees from your client. Copyright is a right which is given by the law to creators to literary, dramatic, musical, artistic work, and to producers and cinematical films and sound recording for a limited period of time. Copyright protections, that must be the original, because as I said, sometimes what happened that writing the article, it would be easy if you are copy paste from some other article, but writing your own article in your own language, that is something different. So in the copyright application, they should first check that you are not copy paste from any other one, and the work must be fixed or presented in tangible form such as a writing, film, and photography, and also created by the qualified person. This all are the basically that you can take the protection in copyright. Number first one, that is artist. Second, that is literary. Third one, that is musical. And the fourth one, that is dramatic. Artistic, you can say like any paintings. If the any painters, you can give the advice that you can take entire paintings copyright over there. Sculptures, graphing, cartoons, photographs, maps, even the buildings, that particular models of particular building, you can also advise to the builders that a particular model of building, they can take the copyright for this. Any of the novels, textbooks, newspaper article, magazines, short stories, if you are writing any poems, song lyrics, you can take the protections. So if someone is misusing your particular work, then easily you can file the infringement case. Musical, like the melody, sheet music, pop songs, film score, and I think each and every film must be copyrighted, because somebody cannot misuse and somebody cannot file the suit against this. So every Hollywood or the Bollywood films must be copyrighted. Choreography or the mime and the plays must be, they have to copyright. So you can easily make in the one application, and within 30 days you will get the reply whether your application is registered, whether the application is in waiting process, whether any discrepancies they have showing, or whether they have registered. So this is a particular that three symbols in applications table you can easily identify. If waiting, that means they have not yet received your original application. Second one, as I said, that the discrepancy is there. So again, they have showing in this table. And the third one, that is completely like registered. That means they have accepted your application, and that will be soon sending you soon of this particular certificate of registrations. So this is like the copyright protect the works. But that is like the DVDs, television, advertisements, online videos, film, sound recording, broadcast, that we can also copyright in that. Copyright in essence of bundle of rights. So there are the so many rights with the owner of that particular work, like the reproductions, modification, distributions, public performance, and various other things are there. So reproduction, you can easily changes in that. You can easily modify your work. You can easily distribute with so many people, and also the public performance. So like the public performance also depend. You can take the royalty from that. Who is the author? So there is again different author for the different particular work, like the literary, because in our area literary work is there. So if you are writing a research paper or articles, you must be have to take the copyright for this. So different work have a their different terminology for that particular term. Again, in the literary work or the musical artistic work, you can take the protection of lifetime of author plus 60 years after the years of author's date. Work published which is unanimously and the posthumously, then you will take the protection of 60 years after the year in which the work which is first published. And identify of the author disclosed before the expiry of the shared period, then you will be get the protection for the 60 years following the year in which author dies. So this is the case. Now this is again important to learn. If someone without using your permission using the same cases infringement of copyright, then you should file easily suit with that particular person. So copyright is infringed when a person without license from the owner does something the exclusive right of which is given to the owner, like literary, dramatic, musical, artistic work. Because in the book publishing, writing an article, writing a research paper, there are so many times it happens that somebody is also copy paste from some other work. Then we can file the infringement suit of that particular person. In cinematographical films, a copy of that particular film, because if you have seen, there are so many people are differently debut this film and sold in the market. So this is again the cinematographical film. Sound recording, that is in other sound recording, embodying the same sound recording is there. So again that would be important. Program or performance in which that is broadcasting. So this is again important. So program or a performance in a which the broadcasting is there, then you just need to check. How do I protect my copyright? So as I told you, that is your copyright will arise in a work as soon as it's created. So there is no legal need to register it. However, having a copyright registration is a strong proof that you are the actual owner of the work. So copyright, you just have to identify you are the owner of the work, and you have to write this particular book or whatever the research paper or whatever the film or whatever that thing. You are the actual owner. You are not copy pasted from any other website or any other such area. You just have to protect your work. And there is a simple website is there, that is http copyright.gov.in. You just have to go there and you have to file the applications first of all. And in that applications, if you are an agent, copyright agent, then power of attorney must be required. And your whatever the work is there, then you just need to submit your work and your power of attorney and just submit. And also same will be the courier to the copyright registry Delhi. And they will, once if they are receiving and they are accepting, then they will if they are accepting, then they will get the register within a short time. If no third person object to your application or application passes examination stage, the copyright office will grant copyright registration for your work. So if no third person object to your applications, so there is a no such have any right. They are if you have the C like the copyright, if you are registered copyright, then you can put the symbol of C and the circle. You can see it in the various books or novels. So you can also register with that. So that is you can easily protect your copyright applications. Now again, this is for your learning purpose. This is a completely new, that how you can give advice to a client that if you are coming with this particular features of that particular product, then you can also take the protections in that. So this is like the protection to the idea of designing community, and this industrial design that will play an important role in the trading of consumer goods or the products. And any new or original idea applied to an article whose pattern, shape, or configuration makes an appeal to high performance and industrial design. And protection of industrial design is governed by the Design Act 2000. So this can be possible. So this is that you can see in this particular picture.
Yes, ma'am.
So this is like industrial design. Like the first one, you can see the different type of cupboards, different type of cushions. So in case of clients or manufacturing, or they are coming with such new ideas, then just you have to protect your industrial design. With that, you just again have to make the applications. Now, if you have something of this kind of unique design, which is again attractive, then you just have to file the industrial design. You can see over here that is a different type of the chairs, different type of bicycles and the car. This is again completely new. Now this is a completely new shape and the innovative shape. Then again you just need to have to file this industrial design application with that particular registry. Now this is design that will be look for the article look aesthetic and appealing. Design why they now you can see over here, you can see that that is appealing to eye, that is catch our eyes, because this particular design is unique. This is capturing. Why it's a capturing? Because it's completely new, completely innovative. So you can also protect through the industrial design. Now this glass staircase that is in Apple shop may qualify for both, that is pattern and design. Now you can see over here that is this particular the staircase. This is again completely something unique design. And why that is a pattern, that is completely new kind of concept they are coming. So they have to take the patent on that, and they have to also take the industrial design for the same. So that is again both the pattern and design. Next one, that is the geographical indications. So geographical indications, which is a name or sign used on a certain product, which is correspondence to a specific geographical location and origin. So this is the geographical locations and origin that is particular famous in famous country, in famous town, in famous city, that is famous for particular region. As I told you, that is Bikaner is again famous for this Ratlamni Sev. And again this Junagadh is famous for Talala Keri. And there are various such kind of city over here. They are famous with that particular product. So we also make application under geographical indications. So geographical, either the product which will be famous in the agriculture, either that would be the famous in the food stuff, either that would be the famous in the wine and spirit drink, or the handicraft, or the clothing and the industrial product. So this is like the slide in which you can easily identify that the Jammu and Kashmir is famous for the Skani shawl. Himachal Pradesh, that is Kulu shawl. Madhubani painting is famous for that particular Bihar. Chhattisgarh is famous for that dhokra, Bastra dhokra, and Maharashtra is famous for Sotapur chattar. Gujarat is again famous for that Kutch embroidery. Madhya Pradesh is again famous for the Chanderi fabrics. Kerala, that is famous for Arumutta Kandi, and Tamil Nadu is again famous, and Andhra Pradesh again I have mentioned over here, that is Pochampula Ikat, that is again Tamil Nadu, that is different kind of fabrics which is famous in your country. So that famous in particular the city that you can easily protect over here. So like different cities, or you can identify, they have the different particular the famous product. I think so each and every city they have famous from something. So they can file the geographical indications for that. Now Tejpur lychee that I have mentioned, Gir is famous for Kesar mango. Kangara tea, that is Malabar pepper. Nagpur is famous for their orange. Nasik is famous for their particular grapes. Next is Madhubani paintings. Surat is again famous for Zari craft. Kashmir Pashima, that particular the famous in the Kashmir Bansri Shari, Sangeri handlooms, and again Chanderi fabrics. So this is the some of the well-known geographical indications. So what are the nature of geographical indications? So this particular geographical indication is an intangible asset and identifiable non-monetary resource which create a legal claim to future benefits of the spatial rights and privilege to it. This graphical indications may not be sold, which cannot, where the trademarks and patterns which can be easily sold and transferred. But this GI which cannot be sold, transfer, since they are the collective own and certification mark and which is controlled by the entire state. And the useful life that is indefinite. So last one, that is once you will protect this GI, that the production of GI label product is always geographical confined to that particular region, to that particular locality and territory. That provide, yes, this will be the famous in this particular city. This is again famous, then you should buy this, because sometimes it is happen that whenever we are a visit in some cities and they are saying, yes, this is a famous product. But again, they have to take this GI and they have to already take the protection for the sale. Last one, which is most important for any of the manufacturer, any of the trader, because they are coming with the new and new products and manufacturing. So if they have any trade secrets, because as I discussed with you in the Coca-Cola and example of the iPhone, they are take the trade secrets for the process of making Coca-Cola as well as the iPhone inner softwares and whatever they are using. So this is a trade secret, that is legal term of the confidential business information. It can include any information that is valuable to its owner, that the owner want to keep this particular the secret. And it may include like the recipes and again the formulas, other special processes, devices, methods, techniques, business plan, research and development information. So here they have to include like they can take the protection and recipe, they can take the protection and formulas, they can take the protection and spatial processes, they can also take the protection of the particular methods that they are using, the techniques, and the business plans, research and development informations. So there are the so many things are there that you can take the trade secret. So trade secret can be also possible in the financial informations, also in the scientific, that is the particular the process of making particular the product, technical and the commercial. Like sometimes some new methodology are using for calculating the salary or the calculating the other things, so they can also take trade secrets in that. Financial informations, like whatever they are using the softwares and whatever that thing, so they can also take the protections with this financial information. Now technological advancement made the job of the creator, which should be very easy. It's also meant the job of the copier is must be easy. So create yourself rather than using others' creations. So my over conclusion over here that like it would be very tough to making your brand. It would be very tough to creating a brand and reputation in the market. So before someone is using it, just you have to take the protection in that. And also this kind of the awareness you can also tell to your client, so that your client must be aware about all these things. So many times I have seen that various products, and in my experience there are the so many clients are also this kind of things which also impact to the goodwill of that particular person. So if someone is misusing your brand, if without your permissions, so this is again a step that infringement should must be filed with that you can easily take the protections. If you are seeing that someone is misusing your brand and if you're not taking any actions, so this is that the case that you are not protecting your brand. So first step, give advice to your client that you just have to protect your either the trademark or either patent or copyright or trade secrets, whatever the case may be. So you just have to protect your mark. This is the first. You can also give advice like the Startup India certificate is there. If you are registering after that, then you will get this so many benefits. And in case of someone is misusing the brand, then the civil suit that must be filed, infringement, and you are charging like 3 lakhs, 4 lakhs, whatever the shoot amount is there, you can ask with your particular the dependent. So that is defendant, you can ask from them. So like petitioner, they can file the application and they can grant like defendant that whatever the infringement, whatever the shoot amount is that they are asking from them. So you just being a CM members, that is you just give advice in IPR. You can do also practice in IPR. The area that you can do practice like the trademarks and the copyrights, that is a must, because this is like which will be also helpful for everyone, because incorporation of a company, that is again that would be very easy because that you are doing in day-to-day practices. But if you give additional advice to your client that you should also protect your name, you should also protect you first of all you have to create something new logo, and then you just have to file the application trademark. So this is benefit for you, and this is again addition that addition in your practice area, that you just have to earning again in this particular area of IPR. So this is the benefit from all the members, and they can get your clients that will be get the protections out of this. And intellectual property right, there is again the vast area, and very much because in the shorter time I have explained with you that is what is basically the trademarks, copyrights, patents, and the geographical indications, and how you have to file the applications, and also you can easily make these applications easily, and how you have to get the connected to your client, and you have to say that no sir, you have to do with this, otherwise this can chances that may be possible. So these things also possible, so you just need to take the advice. And this is a very vast area of intellectual property rights, because as I discussed with you, there are total 6 types of IPR, that is trademark, copyright, patent, GI, and industrial design and trade secrets, and each have there is a long such discussion is there. But in this webinar, the overviews and how we have to do the practices and how the opportunities for CA members, they can do such all these things. So I have tried my best to explain with you that is what is important in IPR. You can do the practice of IPR, and that is easy. So that is I conclude over my session over here. I hope everyone have enjoyed these sessions, and in case of any such question in your mind, so you just have to ask me any questions related to IPR.
Thank you, madam. Thank you, Dr. C.S. Yashree Dixit, ma'am, for your wonderful session and enlightening us on what is an IPR and the types of IPR, and throwing a light on why one should actually register for an IPR and their purposes for IPR and benefits of IPR that one can have. And also enlightening and throwing a light on the role of chartered accountants in IPR, and giving the exposure, how one chartered accountant can expose himself and can practice in the areas which can help him in giving the client services regarding IPR. Thank you, ma'am. Thank you so much, ma'am, and for a beautiful session. And now I would request if anyone have any questions. For next 2 minutes, we'll be taking out the questions. If anyone have, they can ask ma'am for anything. Gangadhar garu, you can unmute yourself and ask the question if anything is there.
Any questions from any members, you can ask, or in fact, you can also mail me your questions, that is cs.yashree@gmail.com, and my WhatsApp number that is 8690830431. You can easily connect me over here in case of any such doubts or the questions which is going in your mind. And also, I think so I will like to request to Sir Satyaraju sir that share my PPT to each member. So if some members who are skipped with any slide, so they can also learn from my slides and they can read for that.
Sure, ma'am. Sure. One small doubt, ma'am, regarding trademark registration. Like you said, different types of IPR have different validity. Like trademark, it is like just after 10 years we can have a renewal. So what if one does not renew and he forgets to renew, and after 1 month or someone takes away the trademark? Is there any what is a remedy against that one can have?
Okay, so like the trademark registry, first of all, before the completion of 10 years. So once completion of 10 years, so completion of 10 before the 6 months of that particular 10 years, they have sent one letters that if you are not registering again further your brand, then your trademark which is not continuing again, which is not registering again. So if in between somebody else making these applications, and there are chances that they will also get registered with this particular name, because it's our responsibility, as I said, that before the 6 month of completion of our mark registration, it's our responsibility that we just have to re-register ourselves, so that again we can take the protections. Otherwise, in appearance case, because in the so many cases I appear, I make the challenges over here. That is, it's a responsibility of the client or whatever the agent. If they are not registering, then that mark which is now after that particular month or after that particular year, which is not registered, and there is a no such amicably option is also available. So that is, sometimes again registry will accept these applications after this due dates, but in between someone is coming, like one of the my case, and I have also appeared in that matter. So I have challenged the matter that and registry is accepted and my mark is registered in between.
Yes. Okay, ma'am. Thank you, ma'am. Thank you for the reply, ma'am. Yeah, so I would thank all the members, all the senior members of the branch for their presence, and today's speaker, CS Yashree Dixit, for giving her valuable time and throwing and enlightening each of our members on IPR. I also thank the technical team and staff of the branch for making the session successful. Thank you, ma'am. Thank you so much. Thank you, everyone.
Thank you, all of you.
Yeah, thank you.